Between the time that the blasters were there and the excavation dug the hole after the blasters were done, something got moved. And I can't tell you who did it, but they obviously were not in the correct location when it was done.
Yeah, so I understood that from your good letter, but my question is, why before beginning the actual excavating for the forms, for the concrete, why was not the setback line restored? That wasn't a topographical problem.
Correct, and I entrusted in my excavation contractor who uses a GPS system to have it in the correct location. And I also would like to think that sometimes code enforcement would let me know that as well.
Well, I don't believe that's their responsibility. So you trusted him, but you did not yourself go to the site knowing how difficult it was to make sure that before they...
Correct. I entrusted that my stake was still on the ground.
Okay. Well, all right. So that's what I wanted to establish. Because it would have been possible to restore that line before the first form was placed.
Correct.
And
yeah.
before the cement was poured.
Yes. Yep.
And then you said that the problem with him placing it closer was not discovered until the surveyor came, because time frames between surveyor and excavation contractors didn't line up.
Correct.
There was no way to alter that?
Well, unfortunately, everyone's busy at this time with construction. I understand that, yeah, but once I did realize that the lot was in the what I thought the wrong location, the surveyors confirmed it. So.
Okay. Yeah. I just want to clarify that. Thank you.
So you mentioned the excavators using GPS.
Yes, correct.
So having had a little experience with that myself, we use it every day.
Mm-hmm.
Every single day.
Sure.
It can make you a ton of money because it speeds up the process. We get to a point where we rely on it. I don't know that it is the case in this situation, but I have experienced where the GPS has lacked a correction, because it's always trying to shoot satellites and it's always trying to do that stuff. And so you can think you're in the right place, and if you don't take the time to, prove the math, so to speak, and I'm not saying that that's what happened in this case. I'm just saying that having experienced where you get to a point where you rely on something that has been so reliable, mm-hmm. and then all of a sudden in the blink of an eye, you're off. I can understand a little bit. So I'm not saying that's an excuse, or we're going to have to go through each one of these, but mm-hmm. There's plenty of opportunity in a construction site to do good things, and there's plenty of opportunity to make a mistake as well. And sure. I don't think anybody on this board is in the business of penalizing somebody for that kind of thing, but we do have an ordinance that we're supposed to be going by, and we're going to try to figure this out to make sure that everybody's treated fairly and appropriately. Any other questions?
Just one, Mr. Chairman.
Sure.
I just want to go back to what Mr. Sterling was, I think, trying to get to, and I'm a little bit curious too. You say in your letter that you conducted your usual as-built survey site plan for the customers. How far into the building process were you? Was it just you had laid out the concrete forms?
The foundation was in the ground, and the framing was mostly complete by the time the survey was done. I brought it up to the town because I knew there was an issue.
Okay. Yeah. So you were well into the project before
Correct.
this was
Yes,
was
correct.
discovered. Okay.
Yeah.
Yeah. Thank you.
I got a quick question.
Yeah, go ahead, Mr. Weiser.
The surveyor set the original setback stakes, or did you guys,
No, I set them.
based on,
Well, the property pins were in the ground. The corners were there, and we set this. I was originally like 63 feet off the front property setback, and it didn't end up there at the end. So
because you're not a surveyor, you're not
Correct.
You don't know if you were 63 feet on the face of the earth back.
Well, the excavation contractor has a GPS system like Mark was, and when they work correctly, they're pretty accurate.
So he verified
Yeah.
your stakes were,
Yeah. Somehow, I don't know if one of his workers didn't know how to use the GPS when they showed up the day they dig the foundation hole, but it was not in the correct location.
Thank you. I see that we're joined by Gary.
I'm sorry.
No worries at all. I guess we should just take a quick moment. We've started the discussion. You did miss the presentation. Have you read the material?
Yeah.
Are you, I'm sure we'll get into some questions. Is there anybody has a concern with Gary joining the discussion at this point?
No, not at all.
Thank you.
Just
Yeah,
I'd like to ask the applicant also whether he has any
Yeah.
concerns about Mr. Baca.
sure. Would you,
So can you say that again?
so Gary has just joined the meeting. He was a few minutes late. He's a board member. Do you have any concerns with him joining the discussion at this
No.
point? Okay.
Thanks.
Most of what we've covered at this point has essentially is in the information. We've dug down a little bit deeper. It seems like there's the one thing that I heard that I don't think I saw in the actual information was that the excavation contractor was using GPS. And there's basically between the time the original foundation was laid out and the time it was poured, something must have changed, or they believe something changed. And one of the challenges on the site was blasting, which was mentioned in the application. And we did clarify which criteria. I count 7 criteria that we're working on. Is that pretty much it? Which are on my book, page 15. I don't know if everybody's got the book with them, but we can go back. We'll go back through each one of those as we discuss. Further questions for the applicant at this point?
I got one.
Yes, sure.
So at what point did you determine that foundation was wrong, and who did that? Who determined that?
The surveyor, I mean, I had the surveyors
Why did they get involved?
because I thought it was in the wrong location, but I needed to have it checked.
Yeah.
Yeah. Yep.
I have a question.
Yes.
Do we know what kind of GPS they used?
I don't know. It's CR Tamberg. I think they have a pretty decent GPS
Differential
system.
GPS is almost, you can't argue it, but I don't know.
Yeah.
If they just used the general handheld, then they're.
No, they got a regular setup. They're accurate if they're set up.
If they're set up and corrected
Right.
correctly, they are, like I said, we use them every day.
They're less than 1/10 of an inch.
Right, that's differential.
All right. Further questions for the applicant?
What's the intended use of the home?
It's a single-family residential home. These are the homeowners here. They actually split the lot off from their parents right next door, so.
Okay. So one of the questions we have to answer is whether this is going to be used as a year-round residence, so I'd definitely like to hear from them about their use plans for the property.
Yeah, please.
Hi, Brendan Joyce. We'll be purchasing the property back. Yeah, we live in Gorham right now. We're hoping to, well, sooner rather than later, but we're hoping to sell our Gorham home, but move next door to our father and mother-in-law.
So essentially, it will be your year-round residence. It's
Oh,
not a
yeah.
camp, it's not a,
Yeah, I do not have beach vacation homes or
Okay.
anything.
All right.
Not Airbnb?
No,
Okay.
absolutely not.
not a rental.
Mine, hopefully.
Okay, yeah,
Thank you.
thank you.
Thank you.
No, yeah, you can sit, yeah. Well, unless anybody else have a question for him? Okay. And I know the struggle that you'll have with that, Ben, for a second, but it's a very common occurrence in the construction industry for the lot to be transferred to the builder while the builder is building it, because the builder never wants to take the risk of building a house on somebody else's lot. So I think and maybe I should follow up with this question if one of you wants to. Was it broken off, put in a family name first and then transferred to the builder, or was it broken off directly to the builder first and is? Okay, so if you wouldn't mind stepping just back, because we want to capture that for the record. So originally, the lot was broken off into your
Ed, you name. might have to, it was given to us.
Okay.
And then we transferred it.
Okay.
It's not a recent subdivision either. He's held the lot for over 20 years.
Yep.
So yeah, it was given to us and then given over.
Awesome. Thank you.
Yep.
So since it sounds like we have an abutter here, it might be great to ask whether there's any impact on the abutters. Just get it on the record.
Sure. Technically, if you're the abutter, we'd like to ask you to step to the podium. Good call. I like that. So as part of our ordinance, one of the things we consider is whether or not an abutter has any concerns with that particular application. But before you do that, if you would state your name.
Oh, sure. Edward Doyle, and I'm next door at 63 Harding Road. The property that we're talking about is number 59 Harding Road, and we have no issues at all with any of the constructions.
Excellent. Thank you. Any
You're
other
welcome.
questions for? Okay. Thank you.
You're welcome.
Any discussion amongst the board, or I'm happy to start down the list if that's the pleasure of the board?
Well, I think we should begin.
Yep. So the first criteria that we're looking at is that the need for the variance is due to the unique circumstances of the property and not to the general conditions in the neighborhood. Anybody have a discussion on that? I would just soon, rather than go through this twice, I'd rather make a motion, and maybe that's what we should be doing, is making a motion, having discussion on each one of these as we go through.
Yeah, I think in terms of procedure, it would be proper to have a separate vote on every single one of these
of course.
criteria, and then a
Right.
final vote one way or the other once all of those criteria have been dealt with. And I'll be keeping notes for a written decision as we go.
Yep.
If you want to make the motions, I'll second them.
Okay, so I make a motion that the need for the variance is due to the unique circumstances of the property and not to the general conditions in the neighborhood.
Seconded.
All right, so we have a second. Is there discussion on that? My discussion would be, and before I interrupt, go ahead.
Oh, go
No,
ahead.
it looked like you were going to jump in, but,
Don't go.
okay. So I guess the only discussion or thought process I have on that is that, we've got ledge in Maine. It's not unique in some ways, but when you run into it, it feels awful unique. And so it leads to, hey, can we fit it here? Can we turn it a little bit to avoid a little bit? Can we do this? Can we push it back? Can we pull it forward? Can we do, all those things? And it seems like that condition is what has, driven the start of the issue here. So that's why I made the motion in the form that I did.
Okay, I just wanted to ask a question of Ben. So I know we have to vote on each one of these, but I don't see this one as relevant. So how do we address that if you have that feeling like I do?
Well, even with that feeling, they're all relevant in the sense that in order to grant the variance that's being sought, the board needs to find that each one of these criteria are met. It certainly could be, I guess, it's certainly the case that there are certain criteria here that are more relevant than others that are going to take more of the board's time. But again, you're tasked with making a decision based on the information that's been provided to you. And you can infer from that information what you need to in order to make that finding. So I guess the point I would make is that just because there hasn't been much discussion about a particular point doesn't mean that the board can pass over a particular criteria. You have to make a finding one way or the other.
Right.
Yep.
Thank you for the question. Is there other questions? Discussion?
The discussion that I would add is that I am convinced that the alleged circumstances on the property presented a unique challenge that sort of started this chain of events into motion. Anytime you've got significant amounts of blasting, you can do everything right and still mess things up, so.
Further discussion? All in favor? C6. All opposed? 1. Second criteria is, and I guess I'll just take a second to clarify. We're going to go through each of these criteria. If one of these criteria doesn't reach
Majority.
a majority, thank you. Why, that word escaped me for a second. A majority, we then can't vote in the affirmative for the variance. Would you agree with that statement?
Correct. In order to grant the variance, a majority of the board needs to vote in the affirmative that each of these 7 criteria are met. It doesn't require a unanimous vote. I believe I had my head down for one moment, but that last vote was 6-1.
Correct.
Correct.
And-
Okay.
yep.
So every vote could be 6-1.
Yep.
It could be 4-3.
Yep.
As long as the board affirmatively votes that all of the criteria are met, then you can grant the variance. But if one of those 7 is not met, then the variance cannot be granted.
Okay. So the second criteria, and I guess I'll just make the motion. I move that the granting of the variance will not alter the essential character of the locality.
Second?
And,
Thank you. Discussion on that particular item? All in favor? That's unanimous.
Chair, can I just
Yes, please.
get in? Regardless of the fact that there's no discussion, there's going to have to be some stated reasoning as to why the board found that that criteria was met.
Okay. I don't mind backing into that one. That's pretty easy. I mean, essentially, the applicant provided some, although it, albeit not super scientific information, but information that houses in the neighborhood are closer than this particular house. It's not going to alter, in my opinion, it's not going to alter how anybody in that neighborhood uses their homes or their property. We had an abutter stand up and say that being one of the closest ones, they're not bothered by it. So that's my reasoning. I see some nodding heads.
I'll also say that I found the photographs persuasive on that subject.
Agreed. Number 3, the hardship.
You want to vote on it again after that?
I don't.
Do you have to vote on it again, or you good procedurally with it?
I'm fine with that. I'm fine with it as it is procedurally. That'll
Yeah.
be
No,
reflected in
that's
your
great.
written decision. So,
Item 3, I move the hardship is not the result of action taken by the applicant or a prior owner.
I'll second.
that.
We have a second. Discussion?
It sounds to me like the applicant took reasonable measures that are kind of seem to be standard in the industry to ensure that he was complying. So in cases like that, I don't think it's appropriate to assign fault when somebody did what they were supposed to do, lined everything up the way that they were supposed to, and something happened. I don't think it's appropriate to assign fault to the applicant in that circumstance.
Fair enough. There is such a thing. Further discussion?
Well, yeah, I disagree with that viewpoint entirely. The applicant stated that they made a mistake. And in this case, it wasn't one contractor, it was 2 contractors. The subcontractor failed to establish the correct location in spite of the blasting, and I understand that was a mess and whatever, but that's part of construction. And the contractor, the homeowner, are solely responsible for making sure that the project complies with the code. So, and then the applicant said that they were busy. And so, I don't know, I mean, the applicant is responsible, ultimately responsible for the successful completion of the project, every step. So it seems to me, and especially in a difficult project, that the GC would be there before the next step to make sure all the ducks are in a row. The line was previously established. The 50 feet was available. It was in place originally. I just don't understand how that couldn't have been restored before going to the next step, because each step in the project is, what do you say, is a bigger investment, it's a bigger commitment, it's a, and this grew exponentially. They started constructing the building after the foundation was poured. So there was a point at which, even if the foundation was poured, I would think someone would be in there to triple check, are we meeting the setback? And we had an applicant in September of 2024 who, at least they didn't get the superstructure up, but they had a foundation poured, and they were off 2.5 feet or something like that. And, and that was because they didn't make the effort to establish clearly where the setback line was. So I can't, there's no way. This was, the reason we're here is because of that lack of oversight or follow-through, or whatever you want to call it. You can't blame it on GPS. It could have been established by hand. You could have gotten a surveyor in there, even if it wasn't the scheduled surveyor that you normally use, to say, I need you for an hour or two, please verify the property line, and then I'll draw a tape 50 feet from that, and I'll pound as many stakes in as necessary. I mean, it's an awful situation, but that's the way I see it.
No, understood. Further discussion? Typically, we do point out that previous decisions don't set precedent, and I know we've made decisions in many different cases. I've sat here long enough, and I remember a very similar situation where the GPS was the issue, and the board did decide that it was acceptable that that was the issue. They granted the variance for that one. I remember the one that you're talking about. That situation is slightly different. And again, I fully hear exactly what you've said, because I get it. But I would also, having a little experience in this area, I will tell you, winter conditions, you're fighting, you're trying to get concrete poured before things freeze. You're trying to get, trying to line up all these ducks, and none of these ducks want to, like you said, getting your ducks in a row is definitely the challenge. That's the challenge of anybody who's in this business. And the ducks you're trying to line up don't want to line up. They got their own schedule they're trying to keep. They're trying to be in all the places that they've been promised to. We already know, and this is just a comment on the world in general, there aren't enough people to do the jobs. So stopping and waiting, especially in winter conditions, is not usually an option. And I'm not saying that clearly rushing leads to, we say what I do, slow down, you'll go faster, right? So, Mrs. Sterling's correct. Had you slowed down, you'd be further ahead now than you were had they waited. And that's why I go kind of both ways on this. But I do also try to look at it and say, the hardship is not the result of the action taken by the applicant or the prior owner, because you've got ledge, which makes you do that little dance of where can we twist it a little bit and make it fit. You've got, tape measures and grade stakes and people working on the site, and then you've got GPS that you grow to rely on. And I wish I could sit here and tell you that we have grown to rely on that GPS and we've never made a mistake. I can't tell you that. What you hope is you catch the mistake before it costs you a lot of money. And so that's, maybe I'm surely projecting my own experience onto this situation. And maybe that's, maybe that's fair, maybe that's not fair, but I can assure you that that I've been in these situations where you relied on something that you've relied on many, 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 many times, and it's worked every time until the one time it didn't, and then it leads to an issue. So I'm not pushing one way or another. I'm saying I think I can understand it.
Can I ask Scott a question? Please. They self-reported, correct?
Yes.
So the sub-blasting contractor made an error. They relied on the spot that you had poured and started to build. As soon as they realized that, they reported to you.
Yeah.
Thank you.
Mr. Chairman, if I could add just my 2 cents worth, I hear exactly what Mr. Sterling is saying. But in my 37 years of construction lending, one of the things that we always tried to do, and I have to emphasize tried to, is make sure that the surveyor was out there before the concrete was poured. Because if there was a mess up, this could be avoided. But I think we all agree that this is a unique situation. We have ledge, that we have weather, we have, I think I counted 8 houses on that one road that don't comply. So I'm balancing, trying to get the whole picture here, and I think that's one thing that we need to not forget, is that there is a bigger picture here. So I just wanted to throw that out for consideration. Thank you.
Thank you. Scott, I have a quick question. And maybe I shouldn't ask this because I maybe don't want to know the answer, but do you think if they hadn't self-reported, you would have caught it? I mean, you don't typically double-check those with a tape or any kind of instrument, correct?
No, usually we find most of these when, actually, we find them a little later in the construction, usually when the mortgage, before it gets switched over, the bank will send somebody out there. That's usually when we know about it. It's usually almost 100% done at that time.
Yep.
I think that just because something could have been prevented doesn't mean that we need to assign fault to the fact that it wasn't prevented. I think the real question is, are the steps that the individual took reasonable under the circumstances in that situation, in the industry they work in, and the resources that are available to them? That's what I'm looking at, and that's why I still think that I am reluctant to assign fault and do not believe that this is the fault of the applicant.
So I have another comment
please.
on what you were saying because of the topography of the site. The lot indicates that this is a deep lot. So so ledge is a problem. If the lot was such that a setback was then going to be on the edge of a mountain, for instance, or a swamp or something that was not workable, I would maybe look at this different. But this lot is deep, so I don't see any issue with moving the hole back 5 feet, 10 feet, whatever.
Having spent a ton of time running on Harding Road, probably got 1,000 miles on that road. I run by this lot that many times. The problem, and I would, if the excavator, I assume you're the excavator, is that true? I'm the other brother. Okay, you're the other brother. So if, could I call one of you up because I want to ask you some questions to help make sure I'm not guiding this. My recollection of that lot is that the highest point is closest to the road.
Correct.
It drops off.
It drops off significantly. There's no topo on that survey. I know it looks like a big giant lot, but it's not.
Yeah.
It drops right off in the backyard very, very quickly to a wet area. They all have the pictures, but I don't know if it actually shows.
It's hard to see,
Yeah.
right. And so the other thing I would say is, and to answer your question, Craig, leach beds can only go where the leach beds meet the criteria. When you're building a house, if you can avoid a pump, you want to avoid a pump. The way to avoid the pump is to build the house near the highest point of the lot and let gravity do its work. We push it back, it drops down. Yes, you avoid the ledge, but you probably add at least as much cost in fill that now needs to go there. You need to run the power further, you need to run the driveway longer, and then you're probably going to end up pumping to the leach bed. So, and just my experience, so don't let me put words in your mouth.
No, you're
But-
correct.
But
Yeah.
did I miss any consideration as to why you wanted to hold it towards the front of the lot?
No, you're correct, and we actually blasted for the septic tank when the blasters were there. That's how much ledge was on the lot. So.
Right. And then with the amount of ledge, there's usually only a couple of pockets where you
There
can
was
get.
only a certain location where we could put the
Right.
septic as well, so.
So that, I mean, that really goes back to number one more than anything else, is that the unique circumstances of the property. Again, it's not unique in the sense that it never happens anywhere else. It's just that when it happens, you find it very unique and your wallet finds it very unique. And again, I'm not trying to rebut what you said, but I'm just like adding information the way I see it and trying to grant that to the rest of the board. Is there-
Right. But then there are other alternatives also.
Sure.
You could change the footprint of the house.
100%.
And all of this can be done before big dollars are in the ground. So, and to Pavel's comment, you can call it fault finding, I call it accountability. You hire a professional to manage a project, the code is very specific. I expect them to do whatever is necessary to accomplish that. And if adjustments need to be made, you make them before you put my dollars in the ground. So call it what you will. It's unfortunate busyness or oversight or whatever you want to call it. Should have happened, should have been corrected before we got to this point.
Fair enough. Just one clarification.
Sure.
Question, because Mr. Sterling did bring it up. When you said, you used the word busy in your description, I took that to mean that other not that you couldn't
Correct,
be
the
there and you
surveyor.
were too busy.
Yes, correct.
But that the people that you were relying on had other things on their schedule, so it took a moment for them to get there.
Correct.
Okay, so yep, thank you. Discussion further on this particular item, or criteria, I should say. We have a motion and a second that the hardship is not the result of the action taken by the applicant or the prior owner. All in favor? 1, 2, 3, 4, 5, 6. All opposed? 1. The fourth criteria, I make the motion that granting of the variance will not substantially reduce or impair the use of the abutting property.
Second.
Have a second. Discussion?
I think we heard from the abutter that there's no concerns, no issues. Sounds like it's a family that wants to live together, which is awesome.
Excellent. Further discussion? All in favor? That one's unanimous. Criteria 5, that the granting of the variance is based upon demonstrated need, not convenience, and no other feasible alternative is available.
Second.
We have a motion and a second. Discussion?
Well, that ship has sailed, obviously.
Yeah, at this point, I don't think there's an alternative. I don't think a reasonable alternative.
Right.
Tearing the house down, blasting again, I just don't, like Craig said, that ship has sailed.
Well, and I think it's basically what your opinion of feasible is, right? So, and I think that's what it.
Feasible, but
Right, is it, yeah.
it's feasible.
Is it
Yeah.
reasonably
Yeah,
feasible?
right,
Or just reasonable.
yeah. Discussion before a vote? All in favor? 6, all opposed? 1. Criteria B, under that same subsection, applies only to variances from setback requirements for a single-family dwelling, that the petitioner, okay, so this is, I move that after hearing from the applicant, that they do intend to live here, that they own the property and simply have used the property as their down payment, that this criteria is met. And will be returned, I should say, the fact that they've used the property as their down payment and it will be returned to them and they intend for it to be their primary residence, that this criteria is met.
So the only comment I have on this
Yep.
is that based on the record that you have in front of you, both the applicant and the current property owner are the home builder, which is an LLC, which as a practical matter can't be the owner or the occupant of the property. I think it's reasonable, based on the testimony that you've heard, to conclude that once construction is done, once payment has been made, that the title to the property will be returned to the former owners, that they will move in. The only question I would have for the board is that perhaps isn't the case as of today, and the question is whether you think that any conditions need to be attached to a particular variance, just for
Yeah, for clarification, I think that's great.
purposes.
Yep.
Under state statute, you're required to record the certificate of variance within 90 days. I haven't heard anything about what the timeline is for that changeover to happen. You don't need to require that to happen within 90 days necessarily, but I would suggest for the board that you may want to consider some sort of requirement that proof be submitted to the code office within a time frame to ensure to hedge, I suppose, against the possibility that something different were to happen and that the property isn't then sold off and used in a different purpose.
Perfect. From this point forward, if you were granted this, how long do you expect the construction to take?
Probably 3 to 4 months.
Okay. In case anybody couldn't hear that, the applicant replied 3 to 4 months. So I guess I would revise my motion to say, I would move that this particular criteria, that it applies only to the variance from the setback requirements for a single-family dwelling that is the petitioner's primary year-round residence. We've heard testimony that the intention is that it will be returned to the customer. So I would say that will be met with the condition that we add that says that within 6 months, because we don't need to run up against it, but within 6 months that actually happens. And if it doesn't happen, you got to return to the board. Does that make sense? So that's the motion.
I'll second that.
We have a second. We have a discussion.
Do we think 6 months is a little tight?
I mean, based on the I would have said the same thing, 3 or 4 months.
He's shaking his head no.
Yeah. So the applicant is saying that he'll have the house done. I'm sure the people, they don't want to hear that it's going to be longer than 6 months. So he would rather, I'm sure the owner would rather say that I said 60 days, but I don't want to put that kind of pressure on anybody. So we're trying to be, and so that will need to be filed and that will need to be taken care of. You will, no matter what, if this variance is granted in full, there is a recording that needs to take place, and then the condition needs to be, would you say the condition needs to be shown to the code office?
Yep.
Okay.
So order of operations would be if the board grants a variance tonight, there's a certificate of variance that needs to be recorded by the applicant within 90 days of tonight. You would attach a condition to that, which would be reflected on the certificate of variance, that within 6 months of tonight, proof would need to be submitted to the code office, both that title has been returned to the former owner and I think a really simple affidavit just testifying that the property is being used as the primary single-family residence of the owners at that point would be more than sufficient. So
the best part about that is I'm going to adopt your language and you get to write that right on there. All right, good deal.
Sounds reasonable to me.
Yeah. So if somebody would like to second the addition of that language.
I'll second.
There we go. We have a second. Further discussion on this particular criteria? All in favor?
Just one question for clarity. Should we add the fact that a certificate of occupancy or COO would need to be generated or not?
Well, a certificate of occupancy is going to have to be issued one way or the other. I think, and that's ultimately up to the board. If you would like to require that proof to be submitted before a certificate of occupancy is received, that's possible. The only concern would be is that, I mean, I don't know this particular process that's used with McDonald, but the thought would be perhaps that a C of O is, I mean, from a eventual property owner's perspective, you're going to want a CO issued before you're taking title to that.
Yeah.
Right? So I would still think that setting a 6-month time limit on that would be sufficient. So it would be variance, CO would be granted, title would be returned, then the proof is submitted to the code office to check that box. If that's not received, then arguably at that 6-month point, the variance would be invalidated and you'd have an enforcement issue again.
Okay. Thank you.
So we'll ask Scott to put that in his calendar.
Yes.
Further discussion on this particular criteria? Seeing none, all in favor? Unanimous. Criteria C, the variance, I move that that it does meet this criteria, which is that it may not exceed 20% of the setback requirements, and I move that the setback variance requested does not exceed 20% and does not cause the area to exceed the maximum permissible lot coverage under this code.
Seconded.
Thank you. Discussion?
20% of 50 feet is 10 feet.
Right.
9.7 is under the 20%. So
Even in Gorham, and I went there. Yeah.
I did not go to the.
Right, that's why we let you do the math. Further discussion? All in favor? That is also unanimous. In granting a majority of the conditions, and so we've already provided conditions, or a single condition, so now we need a motion to grant the variance. So we vote on the whole thing since each criteria has passed.
I'll make that motion. I move to grant the requested variance.
Second.
Excellent. Any discussion on that? All in favor? 6 yeas, all opposed? 1 opposed. With that, do you want to try to write something? I mean, do you?
Yep. I just need to make a couple of edits to this. If you want to take a quick recess, then we can come back and in the past, we printed it off. I'm happy to read into the record and just go that way if you'd prefer, or we can find a way to get copies printed off quickly.
If you just want to read it, if you want to take how long do you need?
No more than 10 minutes, but I'd say
No more than 6 months.
Yeah, no more than 6 months, yeah.
6 months. 5 to 10 minutes should be
Okay.
plenty.
We'll take a 10-minute recess. All right, so we're back. Mr. McCall made record time. I'd ask you to read the findings of fact.
Thank you, Mr. Chair. I did some work ahead of time, so it wasn't, my fingers weren't flying too much. But my typical process here is we have a number of findings of fact, all numbered, and then conclusions which track exactly the language of the code that we've already discussed. I'm going to read paragraph by paragraph, and then just ask that if I have said anything that the board would like to correct, would like to add to, and I will pause along the way. Ultimately, this is your decision and will be adopted as yours. I'm just here to provide you a framework to work from, so please don't be bashful. Shouldn't take too long, and then once we've gone through the entire document, the board will vote to adopt it as its own, and then your chair can come in when the town office is open on Monday in order to sign the document, and we'll be good from there. So I will start. The Town of Gorham Board of Appeals conducted a public hearing on March 19th, 2026 to consider the single-family dwelling setback variance appeal of McDonald Brothers Custom Builders LLC. Board members present were Mark Curtis, Chair, Gary Baca, Courtney Barnett, Pavel Binsick, Dan Nichols, Craig Sterling, and Michael Weissman. The board was represented by Town Attorney Ben McCall. The applicant was represented by Garrett McDonnell. Following the public hearing, the board deliberated and voted to grant said appeal. The board then voted to adopt the following findings of fact and conclusions of law. Hope there's nothing there that needs to be changed. Okay, findings of fact. Number one, the applicant and property owner for this appeal is McDonald Brothers Custom Builders LLC. Number two, the property associated with this appeal is located at 59 Harding Road and is identified as Assessor's Tax Map 35, Lot 12-3. The property is located in the suburban residential district under the code of the Town of Gorham. The property is 2.75 acres in size.
Could we back up just to where you said McDonald Brothers is the applicant?
Yep.
Would it be appropriate to add a line there right after that that says, and holds this property as deposit for construction through the process? Would that?
It's mentioned later on.
Okay, all right,
yeah.
perfect, okay.
I'm happy to.
No, that's good.
But
Yep.
that just tracks who filed the application. Okay. Any issue with number two that I just recited? No. Okay. Number three, the applicant has demonstrated a legal interest in the property by providing a copy of a deed dated June 16th, 2025, and it's Jonah Joyce? Okay. Jonna, okay. Recorded in the Cumberland County Registry of Deeds in Book 41535, page 243. That's in your packet as well. Okay. Number four, the applicant received a building permit from the Gorham Code Enforcement Officer on September 16th, 2025. The building permit allowed construction of a new single-family dwelling on the property. The building permit was granted subject to conditions, which included the applicant verifying the proper front setback and setting survey pins in that location. Okay. Number five, the property is located in the suburban residential district. Under section 300-1.38A4 of the code, all structures within the suburban residential district must be set back at least 50 feet from the property's front lot line when the property fronts a local street. Harding Road is classified as a local street. Okay, number six, significant ledge was found on the property which required extensive blasting to install the permitted dwelling's foundation and utilities. 7, during blasting, the required setback pins were misplaced. The applicant's excavation subcontractor replaced these pins, but did so too close to the front property line due to an apparent issue with GPS. This resulted in the construction of the dwelling within the required front setback, with its closest point being approximately 40.3 feet from the property's front lot line. Number 8, the misplacement of the home relative to the front property line was discovered after the complete framing, roofing, and window and door installation had occurred. It was reported by the applicant to the CEO. Okay. Number 9, according to the applicant, compliance with the front setback requirement would require demolition of the foundation and framed house and complete reconstruction of the same. Relocation of the existing home is not considered a feasible option. I think I'm going to add financially there. Okay. 10, the applicant therefore seeks a variance from the required front setback for the property of 9.7 feet. Granting this variance would permit the completed home to legally remain in its current position. 11, at the public hearing, Garrett McDonald appeared on behalf of the applicant and offered the following additional information. A, the property is owned by the applicant as a deposit from the eventual homeowners. The intention would be to transfer the property back to the, and I put this in quotations, true owners after construction is completed. Okay. B, the setbacks in many neighboring homes are much closer to their front property lines than, I'm going to put, than the constructed home is on the property. A list of such properties was submitted into the record. C, the excavation subcontractor was using GPS to place setback and property boundary pins. There's no explanation as to why the property pins were not restored to the correct location. The applicant entrusted their subcontractor to replace the pins in the proper location. D, the error in location was discovered when an as-built survey prepared by a third-party surveyor was prepared after the foundation was in place. Okay. Number 12, Brendan Joyce, one of the eventual homeowners, testified that he and, it's your wife? Okay, just want to make sure I'm clear on that. He and his wife plan to use the property as their year-round residence once they have moved in.
Once construction is complete?
Sure.
And could you go back a couple paragraphs? You said the property pins were misplaced by GPS, because I actually think it was the setback
Yeah,
stakes.
I should say,
Building setback pins.
Yep.
Was stakes, really,
Yep.
and not pins.
I'm gonna make, so what I'd say instead, Mark, is the excavation subcontractor was using GPS to place setback
Stakes are fine.
stakes. There's no explanation as to why the setback stakes were not restored to the correct location. The applicant entrusted their subcontractor to replace the setback stakes in their proper location.
Yep.
Okay. So back to Mr. Joyce, the property is split off from his father-in-law's property. He originally, and it's actually his wife, originally took title from his father-in-law prior to conveying the property to the applicant as security. Okay. 13, Edward Doyle, a resident of the abutting property, and Mr. Joyce's father-in-law testified that he has no concerns about about construction on the property or the impact of the variance on his property values. Okay. Finally, number 13, section 300-1.23B3 of the code permits the board to grant a variance from the setback provisions of chapter 300 of the code for a single-family dwelling only, quote, when strict application of the code to the petition and the petitioner's property would cause undue hardship, close quote. Undue hardship is more specifically defined in that section and in 30A MRS section 4353 4B. Okay. Conclusions of law. The first two are really straightforward. Based on the above facts and the code provision cited, the board concludes that, number one, jurisdiction. The board has jurisdiction to hear requests for single-family dwelling setback variances under section 300-1.23B3 of the code. Number two, standing. The applicant has standing to bring this appeal as it is the property's owner as demonstrated by the submitted deed. All right, we'll go through the criteria. So 3, single-family dwelling setback variance criteria. A, the need for the variance is due to the unique circumstances of the property and not the general conditions of the neighborhood. Based upon the written materials submitted by the applicant and the information shared as part of the public hearing, the board finds that this standard is satisfied, as the need for this variance is due in part to the significant ledge outcropping on and other natural features of the property, which were the root cause of the issue with the misplaced building. No information was submitted to the board that demonstrated that these natural features were common issues in the neighborhood. And that was 6-1. Okay. B, the granting of the variance will not alter the essential character of the locality. Based upon the written materials submitted by the applicant and the information shared as part of the public hearing, the board finds that the standard is satisfied, as granting the variance would permit a single-family home to remain on a property that is part of an existing single-family neighborhood in a predominantly residential zoning district. Furthermore, it was noted that other homes in the neighborhood were located closer to their front property lines than the home on the property is. That was 7-0.
7-0.
C, the hardship is not the result of action taken by the applicant or prior owner. Based upon the written materials submitted by the applicant and the information shared as part of the public hearing, the board finds that the standard is satisfied, as the applicant took all reasonable steps to ensure the proper location of the home per industry standards. Fault should not be assigned to the applicant for a mistake made by their subcontractor, particularly as the testimony indicates that the subcontractor did make reasonable efforts to locate the proper setback line by GPS. And that was 6-1. Okay. D, the granting of the variance will not substantially reduce or impair the use of abutting property. Based upon the written materials submitted by the applicant and the information shared as part of the public hearing, the board finds that the standard is satisfied, as granting the variance would merely permit the existing home to remain in place. No information was submitted that supported an argument that allowance of a smaller front setback for this home would reduce the value of any adjacent property. I will also say, in fact, a neighboring property owner testified that he had no concern that granting of the requested variance would negatively affect the value of his property. Furthermore, that's where we go. That was 7-0.
Ben, just for clarity, should we, rather than neighboring, should we put in a butter?
Sure. How about an abutting property owner?
Yeah, yeah, thank you.
Okay. 7-0. E, the granting of the variance is based upon demonstrated need, not convenience, and no other feasible alternative is available. Based upon the written materials submitted by the applicant and the information shared as part of the public hearing, the board finds that the standard is satisfied. Should this application be denied, the applicant would be forced to remove and rebuild the home in a conforming location. In the opinion of the board, this is not a feasible alternative, as doing so would effectively double the already expensive cost of construction for the applicant. And that was 6-1. The single-family home in question is the petitioner's year-round residence. So this is where we'll get into a little bit of specifics. Based upon the written materials submitted by the applicant and the information shared as part of the public hearing, the board finds that the standard is satisfied subject to conditions, as the applicant is the home builder, and is is only the property owner at this juncture for financial reasons. The testimony of Brendan Joyce indicates that upon completion of the home and upon final payment, he and his wife will take title to the property and use the same as their year-round residence. In order to satisfy this condition, the board requires proof be submitted to the Code Enforcement Office proving that the applicant has conveyed the property to the former owner for use as a primary single-family residence. And the specifics will be at the end. Anything else? Okay. And finally, the requested variance does not exceed 20% of the total setback requirement and will not cause the dwelling to exceed the maximum permissible lot coverage. Based upon the written materials submitted by the applicant and the information shared as part of the public hearing, the board finds that the standard is satisfied, as the requested variance of 9.7 feet is less than 20% of the applicable 50-foot front setback requirement, which is 10 feet. Furthermore, no information was submitted indicating that construction of the home in its current location would cause the property's maximum lot coverage to be exceeded. Okay. So, based upon the above findings of fact and conclusions of law, the Board of Appeals voted 6 in favor and 1 opposed to grant the applicant's appeal for single-family dwelling setback variance, and hereby permits a 9.7-foot reduction to the front setback of 59 Harding Road, map 35, lot 12-3 to 40.3 feet. The granting of this variance is subject to the following condition. Within 6 months from the date of this decision, information shall be submitted to the code enforcement officer verifying that title to the property has been transferred from the applicant to one or more individuals and that those individuals are utilizing the property as their year-round residence. This notice of decision is adopted by the Board of Appeals, which has authorized its chair to sign the same on behalf of the board. Is there anything else that's been omitted that you'd like to add, change, clarify, anything whatsoever?
Do we need to name them as the future owner, or is it just
I
individuals?
think we picked that up earlier in the document, right? You did name,
I did, and I'm being a little bit lenient. It's really in the very unlikely circumstance that for some reason somebody else other than the Joyces are the eventual owners for this. It doesn't require that they, in fact, be the year-round residents of the property as long as somebody is the year-round resident of the property. So that's just to catch that as a possibility.
fair enough. Do we need to make a motion on that?
Just to adopt the findings of fact and conclusions of law as stated, please.
Before we do that, does anybody have any questions or changes? Move that we adopt those findings of fact and findings of the law. Did I state that correctly? Or
Findings of fact and conclusions of law.
conclusions of the law? Thank you.
I'll second.
Any discussion?
Sorry.
All in favor? 6, all opposed? 1?
That's it.
That's it. I would entertain a motion to adjourn.
So moved?
Second? All in favor? That one's unanimous. Thank you.